Good morning, everyone. Good morning. Happy Monday, as they say here in Washington. I am Harold Kim, Executive Vice President at the U.S. Chamber Institute for Legal Reform, and we're here to talk about BMS Battlegrounds, a panel discussion with two great lawyers to help us really understand the intricacies of personal jurisdiction. I promise this is not going to be like a law school class. We're going to have a nice discussion, a back and forth, and then we'll have some questions from the audience. And I also welcome everybody who is on the web, as this is being webcast. So there's an old saying in real estate that the three most important factors to consider before buying a home is location, location, location. Now, I'm not sure who coined this mantra, but what I can tell you that it's been fully embraced by some of those in the plaintiff's bar, especially when finding the best forum to sue a class action or mass tort lawsuit matter against an out-of-state defendant. Now, to put this all into context, what we're talking about today is personal jurisdiction. What authority does a court have under our U.S. Constitution and the Due Process Clause to render a decision over a party being sued in that particular forum? In other words, is this court the appropriate forum and venue for the underlying lawsuit? Now, according to the U.S. Supreme Court, the personal jurisdiction doctrine protects individual liberty from overreaching courts, especially at the state level. It also reinforces core principles of federalism by maintaining the identity of our country as a union of states with their boundaries and with their territories. Now, for centuries, the U.S. Supreme Court has developed a very complex body of case law in the personal jurisdiction arena, starting with territorial jurisdiction principles from the Pennoyer versus Neff case in 1878. As a side note, this was the very first case that I read in civil procedure, and it still haunts me to this very day. Now, in more modern times, we were, of course, introduced to the minimum contact standard from International Shoe. And this is a standard by which a defendant out-of-state company would be subject to a local state's long-arm jurisdictional reach laws. And it was case law that was developed in successive years. But it really wasn't until the 1990s when the light bulb went off for the plaintiffs' lawyers. It was at this time where they figured out that they could go forum shopping or conduct litigation tourism, regardless of jurisdictional rules, to hail an out-of-state defendant into a local state court and press a case that might be extremely sympathetic that could also generate hundreds of millions of dollars in damages. Many would describe this practice as forum shopping. Others, like I said, litigation tourism. I had a former friend and colleague who actually called it judicially sanctioned kidnapping, and I don't think that that would necessarily be far from its mark. We've witnessed verdicts in the hundreds of millions of dollars in places like Madison County, Illinois, or Jefferson County, Texas. And home cooking was the name of the game. I personally have been home cooked in Fulton County, Georgia, so I know what it feels like when the principles of law or evidentiary standards are completely thrown out the window and it's a result-oriented case. And of course, out-of-state companies, the ones with deep pockets, are the primary targets. Now, Congress tried to do something about this in the class action context during the 2000s with the passage and enactment of the Class Action Fairness Act to bring a lot of these cases out of state court into federal court. But we can't forget about the U.S. Supreme Court, because since 2011, they've been very, very active in trying to shape the parameters of personal jurisdiction jurisprudence in this country. It started in 2011 with the Goodyear decision, 2014 with the Daimler-Chrysler decision, and in 2017, just last year, we had a pair of decisions involving Burlington Northern Railway and, of course, Bristol-Myers Squibb, a case that we are going to dive a little deeper into today. A couple of things about the BMS case. Number one, they were all written by Justice Ginsburg. So she is on the court a personal jurisdiction expert. And the other piece to note is that these cases were all almost unanimously decided. So there wasn't a division within the court when it came to some of these core principles. And the fact that there were successive cases over a period of time, I think you can deduce that the Supreme Court was really trying to send a strong message to the lower courts that we really mean it when it comes to reinforcing and understanding the principles of personal jurisdiction. So it's been 350 days since the BMS decision came out. And today we have two great experts to really help us understand the case itself, but where are we today? How are the courts reacting? What are the plaintiffs' lawyers doing to adjust? And what can you, as defense counsel, do to best adjust your litigation strategies to understand the dynamics of this important case that came out last year? And to help us, we have two really smart guys. First, to my immediate left, we have Anand Agneshwar from Arnold and Porter. Anand's here with us today because he and his colleagues helped write this research product, which I think is a nice snapshot of where the case law has developed since the BMS decision came out. It also sets out a number of key principles that defense counsel should be looking at to adjust their strategies accordingly to the plaintiff's bar, which has been very active trying to redefine and restyle their own litigation strategies. Now, Anand, in addition, actually litigated the BMS case, so he can give some really good firsthand perspective. He's been at Arnold and Porter for nearly 2 decades, probably 2 decades plus, and he is a real expert when it comes to product liability litigation. And if that weren't enough to keep him busy, he's also very active in the pro bono space, protecting civil liberties. So Anand, thank you for joining us. Archis, to Anand's left, is litigation partner at Mayer Brown, and he's the co-chair of the firm's consumer litigation and class action practice, which was recently named as Law 360's premier class action group. So congratulations on that, Archis. Big smile on your face. Archis has worked with the Chamber for years, he and his colleagues at Mayer Brown, and he's also considered a rising star from National Law Journal and also Law 360. So with all of this said, I want to welcome you. Thank you for joining us here on this Monday morning in DC, and let's just dive right into this. Anand, let me start with you. You litigated the BMS case. Why don't you tell us a little bit about the case, what it means, and I'd also like to get some color in regard to Justice Ginsburg, the concurring opinion from Justice Alito, and of course the dissenting opinion from the lone Justice Sotomayor.
So it's an interesting case. We started, Arnold and Porter has been counsel to Bristol-Myers and the Plavix litigation for years. And as in most product liability litigation, the plaintiffs started trying to aggregate cases in bad jurisdictions in Cook County, Illinois, in St. Clair County, Illinois, and in San Francisco. We actually, interestingly enough, after Daimler, we ended up getting the trial court in Cook County to throw out all the Illinois cases. So we were able to clamp down on that jurisdiction, and the plaintiffs didn't take a chance on appeal on that. California was a much different situation, and that was, bitterly fought from the get-go. Now, here's the interesting thing. You might think that after Daimler, it was the plaintiffs that came up with this specific jurisdiction theory as a loophole to get out from under Daimler, but it wasn't. In the California appellate courts, and I argued in the California Court of Appeal and the California Supreme Court, this issue was briefed as a general jurisdiction issue. There might have been a footnote in the plaintiff's brief about specific jurisdiction, but they were arguing exceptional circumstances as the way out of Daimler. A week before the argument, maybe it was a few days before the argument, we get a letter from the California Court of Appeal saying, we want you to address these 3 cases. And all 3 of them were specific jurisdiction cases. And I remember thinking, what is going on? How can this possibly be analyzed as a specific jurisdiction case? All of a sudden, the plaintiffs were like gung-ho, this is a specific jurisdiction case. And without any briefing, basically the argument in the California Court of Appeal was all about specific jurisdiction, and they took this theory that if you basically joined or trumps jurisdiction, and therefore if you have out-of-state plaintiffs joining with in-state plaintiffs, you can create specific jurisdiction. Well, there was a quirk of California. The Supreme Court, interestingly enough, has not set forth a clear test of specific jurisdiction all these years. So every circuit in every state had different tests. And they were able to get away with this. And California, being a state that wants to expand jurisdiction as much as possible, had no trouble embracing a theory of specific jurisdiction. Flash forward to the U.S. Supreme Court. What's interesting about the argument in the U.S. Supreme Court is that there was very little dissent. You came out of that argument feeling that it was a question of whether it was going to be 8-1, 9-0, 7-2, was there going to be a concurring opinion? But it was clear that the Supreme Court was seeing this as a clear case where there was no specific jurisdiction. Now, Justice Alito wrote the opinion, Justice Sotomayor dissented. But what's interesting is I think if this was a standalone case that had come out before Daimler as a specific jurisdiction case, I bet this case would have been 9-0 decision. But Justice Sotomayor recognized what the court was doing, as Harold pointed out, which was one by one effectuating a paradigm shift in the way jurisdiction should be thought about. So having closed the door on forum shopping in Daimler and Goodyear, the court was not about to make this an elastic doctrine in which specific jurisdiction expanded to compensate for the reducing of general jurisdiction. And that is really what Justice Sotomayor was picking a fight with. And she was saying, look, if you're going to close the doors of the courthouse for general jurisdiction, then you've got to let specific jurisdiction do more work to allow plaintiffs to aggregate cases and to get into the forum of their choice. And that didn't get a single other vote. So you really have the entire Supreme Court virtually across the whole political spectrum embracing this new way now of how jurisdiction should be analyzed.
And when it comes to the BMS case, I mean, Bristol-Myers Squibb is a New Jersey-based corporation sued in California by a small group of California plaintiffs, but also a big chunk of out-of-state plaintiffs, where it involved Plavix, and it was a product liability case. And so under those circumstances, the question was, hey, does BMS actually trigger the jurisdiction? Not general, because they're not really registered to do business and they're not operating in California, but it was really the nexus of the actual injuries, because a lot of these out-of-state plaintiffs didn't take Plavix in the state of California. And so this elastic type of argument that was being made in the specific jurisdiction context really seemed to bubble up, and it was, to put it mildly, I suppose, a very novel way of approaching this, right?
Yeah, I think that's fair. I mean, we referred to it a number of times as bootstrapping jurisdiction from the in-state plaintiffs to expand to cover all the out-of-state plaintiffs. And that theory, I think, in our view, and we worked with the chamber on an amicus brief in BMS, would have basically opened the door to specific jurisdiction in any state, because, and you could talk more about Plavix, I'm sure, but this was something that was taken in all 50 states. So if the California theory was right, why couldn't it be that in Louisiana, 10 plaintiffs who took it could then add on plaintiffs from around the country, or Missouri? I'm not picking these states totally at random. These are some of the more difficult places for defendants. So I think that was troubling. And I think the Supreme Court got it right. And I do think, as you said, it is kind of a piece with the general jurisdiction cases. The general jurisdiction cases are all about fairness to defendants and certainty. And that's why, as Harold, as you said, the rule has essentially developed that there are only, for the most part, two places that a defendant can be sued: the place of incorporation and the principal place of business, usually the headquarters. And so if this group of plaintiffs had wanted to sue in New Jersey or Delaware, which is where most, I assume BMS is incorporated there, almost every company is. You could sue in those places with a large mass of people. But Harold, you started this discussion with the phrase litigation tourism, and I think there's something to that the plaintiffs want their choice of forum, and they have a sense of which courts and which judges are going to be more sympathetic to their point of view. But that doesn't mean that a New York plaintiff with no connection to California, where the defendant, with respect to that New York plaintiff, has no connection to California, can go sue in California. In an individual case, that would be, even before BMS, that would have been laughed out of court, I think, even by the California courts. So the idea of this bootstrapping or jurisdiction by joinder, if you step back from first principles, it's pretty troubling. So you must have been pretty bothered arguing that in the California Supreme Court, because it doesn't really make sense with our traditions of due process.
No, what's interesting, I mean, you're exactly right. What's interesting is before Daimler and Goodyear, you'd never have to address this issue in specific jurisdiction context, because all of us in this room, I think I can safely say, learned in law school that basically if you're a company that does business in every state, you can be sued in every state for anything. And that doctrine basically went unchallenged really for a lot of years. And The companies just, went into Jefferson County, Mississippi, and St. Clair County, Illinois, and came up with all these other arguments, but not really jurisdiction. That paradigm of general jurisdiction was so ingrained in our psyche, even among very creative defense lawyers, that we didn't really challenge it. So there had been no case law on this issue in specific jurisdiction, which allowed the California Supreme Court to kind of create it, or the California Appellate Court to create it from whole cloth. Now, the other thing that's interesting, having argued this in now 2 appellate courts and seeing the Supreme Court, is the justices often, and appellate court judges, they really have to be shown what happens in the trenches. Because from an abstract, we're looking at it from just a 30,000-foot abstract level, the question is like, well, what's the big deal? You're going to have to litigate these cases somewhere. Aren't you saving a lot of defense costs by having these litigated in one jurisdiction? I mean, you're going to have to litigate those in some other jurisdiction in Delaware or New York, or in 50 different states. So what's the big deal? And it puts you in an awkward position of having to say, the big deal, Your Honor, is the courts in this jurisdiction, in the trial court, where you get railroaded and the juries come out with like big verdicts, and then the plaintiffs say, Your Honor, I don't know what the problem is with California juries here. They're just as fair as any other jury. So it's an awkward
I think
situation.
we would take issue with that over at the U.S. Chamber.
Right.
Well, so now that the Supreme Court has come out with the BMS case, it's almost a full year out. What are you seeing in the trenches? Do you see a rise in personal jurisdiction defenses being used from these from California to Missouri or to New York or to the Southeast?
Well,
Archie, go ahead and take it.
yeah, I think the answer is yes. I think that this trend of cases has begun to take root with defendants and their counsel. First, as you said, and I agree that BMS doesn't happen. The specific jurisdiction rulings don't happen without the initial general jurisdiction rulings, particularly Goodyear, which I think launched all of this, and then Daimler. So I think those cases put defendants on notice, and then with BMS, my sense, I use the phrase "use it or lose it" because you can waive personal jurisdiction if you don't raise it right away. So every defendant who is thinking about, if they're in a bad place, if you're in a great place, fine, you'll litigate there. But that's not how the plaintiff's bar operates. They pick a place that is predictably terrible for defendants whenever they can, and so a defendant should be thinking about this in every case, and they typically are. And so yeah, it's getting raised, I would say, in any case where there's even a colorable argument. And I believe defendants should raise it because of the risk of losing the argument if you don't raise it from the start.
Well, you mentioned waiver, so let me stay on that topic. With waiver, how does that apply to the cases that were in the pipeline prior to BMS actually being decided? Are there arguments as to whether waiver should apply under those circumstances because you didn't bring it up? But how do you bring something up when it hasn't actually been decided?
Yeah, do you want to?
Well, I just say it's kind of funny because the plaintiffs who were arguing that this was a whole shift in the law for centuries, basically, the Bristol-Myers decision, and saying like you can't change the law, are now in a position of arguing that, hey, defendants, you should have known all the time what the law was. This was clear in the Bristol-Myers decision. I think courts have been pretty charitable, I would say, on amending answers to raise personal jurisdiction after Bristol-Myers, in recognizing that it was the end of a paradigm shift and allowing defendants, by and large, I think there have been some exceptions, but by and large, courts have been allowing the defense to be raised. I think now we're getting to the point where it's a little late for those pending cases, but for the few months after Bristol-Myers, yeah, I was seeing it a lot, answers amended and things.
I agree with that, and I also think that courts that would have said that there was a waiver were also going to be terrible on the merits. And typically you would see something like, this issue is waived, but anyway, you would still lose.
Exactly.
Right. So it wouldn't have necessarily made much of a difference, which is just a reminder that these were courts you didn't want to be in the first place.
Now, I have heard the natural response from the plaintiff's bar could go into a number of areas. One particular area that I find interesting is that they may be seeking other in-state defendants to somehow pull into the case. We saw that certainly with the Class Action Fairness Act and bringing in little old Hilda Bankston, that pharmacist in Mississippi, to defeat federal diversity jurisdiction. That poor woman went through just a complete ordeal, and she was the poster child as to why these reforms were needed. And so our research chronicles a little bit of this, and to see how this could potentially play out as there are going to be new targets that you're seeing in places like California or Pennsylvania. So, Anand, is that something that you're
Absolutely.
in tune with?
Absolutely. In fact, a decision just the other day came out in the Pennsylvania Court of Common Pleas in the mesh litigation adopting this kind of argument. The plaintiffs had argued that the company that made the mesh product contracted with a Pennsylvania company to make a certain component part, and the court said, aha, there you go, specific jurisdiction over this company for any product that uses this particular manufacturing process. Of course, that is not what Bristol-Myers contemplated. Bristol-Myers did not invite lower courts to allow this fishing expedition into any contracts with any third parties that might have had some connection to the manufacturing process. In fact, I believe the Supreme Court said specifically that a contract with a local defendant is not enough. There has to be concert of action. Now, if you contract with a local defendant and then conspire to, promote the drug in a certain way or do something else, that may be a different situation. But just using like a third-party contractor or a third-party manufacturer, there's no way the Supreme Court really countenanced that. Yet that's an argument that the plaintiffs are making everywhere. I am still seeing today the plaintiffs suing McKesson in California with out-of-state plaintiffs trying to get jurisdiction. And what's the argument? Oh, well, if you read the way Justice Alito wrote the Bristol-Myers decision, this was basically a reflection of the lack of good discovery that the plaintiffs did in that case. Because what Justice Alito said, I'm quoting the plaintiffs, is, well, they didn't show this, they didn't show that McKesson distributed the drug taken by these plaintiffs. They didn't show that McKesson was involved in promoting the drug or in handing out labels. So really, trial court, what you need to do is allow more discovery into these local defendants for us to find out that information. And I think that we've got to be on guard with that. I think it's happening in every case, and there's a couple responses. Number one, what's been clear throughout this, as you mentioned, this trio of cases from Goodyear to Daimler to Bristol-Myers, is the court expects this to be decided early on in the litigation. It's a threshold issue. It's not 2 years of discovery before you even get to the merits. It's like right now, is there jurisdiction or not? Number two, third-party defendants don't matter at all unless the plaintiffs can show a credible showing at the outset of concert of action or conspiracy or that third party's involvement with the out-of-state defendant in doing a wrongful act. The contract by itself is not viable. But this old paradigm is so ingrained in a lot of actors, including courts, that these arguments just have some sway with some judges, as we saw just the other day with this issue. So definitely, I think it's something to be on guard about.
So why don't we have some examples? Have you seen certain courts actually allow jurisdictional discovery to reach into some of these threshold issues? I mean, it would seem to me a huge waste of time and resources. I mean, there seems to also be a trend, now that we have a new federal rule on proportional discovery and an acknowledgement that discovery just is not a cheap proposition. So,
yeah, I think it's part of a larger problem in the courts that discovery is viewed as essentially a right of plaintiffs to get, and that it's viewed in a sense as free. What's the harm with doing a little discovery? But in today's modern age, there's no such thing as a little discovery. One document request means maybe 5 million emails that you have to look at. So perhaps that's an exaggeration, but not much of one. I mean, I think the reality of modern e-discovery is such that any discovery is massive and expensive. And as you said, the whole point of jurisdictional rules is that they're supposed to be simple, clear, predictable. So you shouldn't have like a mini trial over whether or not you should have a lawsuit in a particular form. But that is basically what I think the plaintiffs have been trying to do with with some success. And part of what you said, I think, is totally true, which is that you have judges who came up in an era. It wasn't that long ago, really. I mean, how old is Goodyear? I mean, we're talking about even 10, 15 years ago. It was the norm to have general jurisdiction everywhere, essentially, right, in practice. So my sense is that judges are still trapped in that paradigm. They haven't made the shift yet, and so it's they're very open to having their specific courtrooms open. We see this a lot with judges who are essentially not on top of it, and they'll cite precedents from like 1985 or 1999, but those are no longer good law, yet they are relying on them. So, and that spills over into discovery as well. I mean, I think there has been too much jurisdictional discovery because usually these rules are pretty clear. General jurisdiction, you definitely don't need discovery. You know where the principal place of business is. You know where the state of incorporation is. There's almost never an exceptional circumstance that fits. So almost never general jurisdiction in the places where plaintiffs want to sue. And then you look at specific jurisdiction. This is a defendant-centered question, and I think a lot of courts ignore that. Look at what the defendant actually did. That is actually, I think, a relatively easy question to answer without discovery. And the interesting thing to me is the plaintiffs are the masters of their own complaint, so they've actually said what their theory is. That you don't need to dig into discovery to test their allegations. If they had any evidence or a good faith basis to show a real connection between the defendant and the forum, they could put it in the complaint.
Absolutely. Can I just add one thing to that? So I think part of the plaintiff's job really is representing their clients is to try to find loopholes. That's they want to be in these jurisdictions. That's what they're going to do. We have to expect it. Part of the hook they have is the way the Bristol-Myers decision was written. So Justice Alito wrote this decision. Justice Ginsburg, who wrote Goodyear and Daimler, she wrote the BNSF decision, which was argued the same day, which is a general jurisdiction case. But she didn't write Bristol-Myers. I think it would have been written differently had Justice Ginsburg written it, because at oral argument, Justice Ginsburg, in her couple questions, was focused on, isn't this an end run around Daimler? And if it was written like that, like, you guys just don't get it. And we shut down this kind of forum shopping and product liability cases in Daimler. And specific jurisdiction is a narrow doctrine that hasn't changed, and it doesn't change because general jurisdiction is contracted. It doesn't change because you joined with other plaintiffs. It's the same old analysis that there has to be a connection. End of story. If it had been written like that, I think it would have been a lot harder for the plaintiffs to make these arguments that there just wasn't sufficient discovery done in the Bristol-Myers case. But the way the decision was written, it was written like an open and shut fact-specific case. It was written like a no-brainer, not necessarily as part of a paradigm shift, where the court was looking at the facts of this case and basically saying, are you kidding me? There's no connection to California. There's no relationship with the in-state plaintiffs. There's been allegations about McKesson, but there's no facts here showing anything about McKesson. Like, get out of here. This is not a specific jurisdiction case. But because they focused on what was missing in the case, the plaintiffs were able to argue, aha, now if we fill in those blanks, we can show jurisdiction, and they've got a willing audience in some courts. So it's something to definitely be aware of.
So if I'm a plaintiff lawyer and I want to seek jurisdictional discovery, where would I want to go to get a favorable type of ruling on that?
California.
California.
It's unsurprising that it parallels where they want to go to begin with. I mean, the plaintiffs pick their forums for a reason. They think they'll have advantages there. They like the judges. They like the jury pool, especially in mass torts cases. I think with class actions, it's a little different because, it's rare that you expect to get to a jury. But certainly, you're, in a sense, picking your judges, and so you have a sense of how they'll rule on these questions. It's not automatic, and I think, there are judges who are fair in every jurisdiction. I mean, the defense bar spent a lot of time talking about how Missouri has been troubling, but I'm sure you can speak to this. I mean, Missouri very quickly, the federal judges in Missouri took a look at BMS and said, maybe we should slow down here with these trials in light of this decision.
Well, there are immediate mistrials out of Missouri, right?
Yeah,
In
and in the
the
state
talk
courts
cases.
too, right? I think they halted a trial like the same day or day after.
Right. It seems like Illinois and Missouri, they got the message on this, but California, hasn't quite yet set in.
Including federal courts in California. There's been a couple adverse decisions out of federal courts in California, basically suggesting that, like, if you're a drug company and you had a clinical trial site in California 20 years ago when the drug was being studied, that might be enough to get you over the hump for a specific jurisdiction. Kind of really not getting the message. It's kind of ironic that the state that really got slammed down in its expansive use of jurisdiction is the one state where we're really seeing a lot of resistance to embracing the Supreme Court's decision.
Although I think to be maybe more cynical, you see that a lot with California courts, both federal and state, a bit of resistance to U.S. Supreme Court authority. There's a joke for lawyers who litigate in California, which is that the Supreme Court's opinions are advisory in the Ninth Circuit, and I'm not the first one to come up with that. I think that's obviously a little tongue in cheek, and I wouldn't say that to the Ninth Circuit myself. But the fact that joke exists tells you something about
Your pro hoc vice privileges just got revoked.
right.
Only in a room like that would that be funny. Archis, you mentioned class actions, and let's turn to that. The BMS case was not a class action lawsuit,
Right.
but there has been some commentary, and specifically with respect to Justice Sotomayor, on addressing the reach of the BMS decision to dismiss certain nationwide class actions in a class of plaintiffs who may not necessarily have a jurisdictional nexus to the forum state. Why don't you talk a little bit about that?
Well, here's a place where I think there is the potential for perhaps an even greater paradigm shift. For years, I think it was assumed that as long as you had one plaintiff in a particular state, you could bring a nationwide class action in that state. And the BMS decision, I use that phrase of bootstrapping or jurisdiction by joinder, and I mean, a great win for you and your team. I mean, it really underscores that at least in the mass torts context, you can't use a named plaintiff or a single plaintiff in one state and tack on a bunch of other individuals. So that's true in the mass torts context, now pretty clearly established. Why should class actions be different? And so maybe I'll just quickly spin out both the theory and then how this is shaking out. I mean, the whole idea of class actions is that basically it's nothing more than the aggregation of individual claims. And the way to think about it is that if a court wouldn't have jurisdiction over somebody from out of state if they sued individually, why does the class action device, Rule 23 in the federal courts, alter that? And in fact, the federal rules are supposed to work in a way that doesn't change substantive rights. So when Congress passed the Rules Enabling Act, I think it was the 30s, that basically kicked off the federal rules of civil procedure. It basically says, that in an act, when the courts who are empowered to adopt these rules, when you adopt these rules, you can't abridge, enlarge, or modify any substantive rights. And so in the sort of the merits context, the Supreme Court pointed to this Rules Enabling Act, and elsewhere it's pointed to due process, which is kind of tied to this Rules Enabling Act theory, in saying that you couldn't drop essentially individualized defenses because of the class action device. That if a company had a right to raise an individual defense on the merits, in that case under the civil rights laws, that couldn't be jettisoned in service of certifying a class action. And the Supreme Court has, or at least justices on the Supreme Court have indicated that this continues to be a concern in the class action space. In the Tyson Foods case, the Supreme Court had agreed to decide whether you could have a class certified that had people without Article III standing to sue. And the court didn't reach that question, but Justice Kennedy said it was an important one. And the Chief Justice said, basically, his answer was that Article III doesn't give federal courts the power to order relief to any uninjured plaintiff, class action or not. That's a standing issue, but actually standing is a question of jurisdiction. And so it's not that hard to make the move from subject matter jurisdiction or standing to personal jurisdiction, which is what we're talking about here when we're talking about personal jurisdiction is essentially due process. So that's sort of the theory. And to sum it up, if an individual couldn't sue you in California, if that would be laughed out of court, why does the class action device change anything about that? And the answer is it shouldn't. And so many courts have agreed with that, particularly courts in the Northern District of Illinois. There's something like 4 cases that have basically said you can't have a nationwide class action in a place that a company is not subject to general jurisdiction. There are some courts in California that have, unsurprisingly, that have gone the other way. And this is an issue that is going to be litigated a lot. But I guess to give sort of the takeaway to defendants facing nationwide class actions, if you're not incorporated in that state or you don't have your headquarters there, consider resisting because you, A, probably don't want to be there, and B, as a tactical matter, changing a case from a nationwide class action to a statewide class action is, game changing.
Well, do you see this ultimately bubbling up back to the Supreme Court in the next few years?
Yeah, I think absolutely, because I think some courts, and right now it's all in the action's all in the district courts, but it will get to the courts of appeal, and I think predictably there's going to be a circuit split on this issue, and so the Supreme Court will have to consider it. And you can see strands of these issues from Tyson Foods, from the Dukes case and subsequent cases, and from BMS, all coming together into this debate.
Now, what we've heard from the chatter, if you will, from the plaintiff's bar is that you better be careful with what you wish for if you're going to argue BMS in the class action context, because if you do that, we're just going to balkanize class action litigation and go into all of these areas of jurisdiction. And we've heard that in the context of what would happen post-CAFA, that there would be an adjustment period. And so do you give that any type of weight, any concern when you advise your clients as to whether you should pursue this particular area of defense?
So we've been hearing that a lot. In fact, in the whole Bristol-Myers, the Plavix litigation, the plaintiffs' lawyers kind of warned us that, be careful what you ask for. If you prevail here, you're going to start seeing 50 state litigations and things. And I just haven't seen that at all. That's not the way the plaintiffs' lawyers like to operate. The way the plaintiffs' lawyers get leverage against a defendant is by aggregating claims in jurisdictions that are threatening to those defendants. And it's the aggregation and the numbers that often push the defendants towards settling, because all of a sudden you've got 5,000 cases pending in this MDL or in that state court, and the paradigm the judges are thinking is they're trying to end this litigation, and unfortunately, this is a topic for another day. Judges often feel like the only way to end a litigation is to pressure the defendants to settle. And so you only get that kind of pressure if you have a lot of claims pending. So there's no way that in the wake of Bristol-Myers, you're going to start seeing a lot of litigation in Iowa or North Dakota and the like. It's just not what's going to happen. They're going to try to open up different avenues, like in Delaware. I'm seeing more litigation in Delaware, where a lot of companies have their state of incorporation. You're seeing, more litigation in New Jersey, where a lot of companies have their principal place of business. But you're not seeing this fractured litigation happening. It's not cost effective for the plaintiff. It doesn't accomplish their goals.
No, I totally agree with that. I think that this threat is largely empty. I mean, I think one thing needs to be stated. BMS is a huge win, and I think it will have a big impact on class actions, but it is not as though nationwide class actions are dead. There are 2 places where, all but the most aggressive defense counsel, and I'm not quite that aggressive, would admit that you can face nationwide class actions in places like Delaware where you're incorporated, or places where you have your principal place of business. Hard to argue otherwise, given that general jurisdiction is all-purpose jurisdiction, right? So you're not going to have 0 nationwide class actions. It's just going to be happening on different turf, and then the plaintiffs would prefer. And what I think will actually ultimately happen is if some set of plaintiffs' lawyers file 30 or 40 single state class actions, there will be some negotiation in the federal system. There will be an MDL. I think, and the other point is that defendants have the right to assert personal jurisdiction, but you could waive it. It's, I think, it's fair to say that if there was a lead plaintiffs' counsel group and defense counsel, you could talk about an even playing field, a jurisdiction that was fair for all, and maybe agree on that. I think the problem before BMS was that plaintiffs held all the cards. I think it's unrealistic to say that defendants hold all the cards now. I think it's a more even playing field.
And isn't really that's the way it should be, right?
Yeah.
I mean, it's an adversarial system. It should be an even playing field. let the facts and the law play out where it should go.
Yeah, no, I was just going to say that that's kind of been happening in the MDL context for some time. When the one party or another wants to move for an MDL to the JPML, everybody knows it's unpredictable where the JPML is going to send the case. So it's in both sides' interest to try to agree on a jurisdiction that maybe is not in either side's dream jurisdiction, but is a place where both sides can get fair treatment. Because if you go to the JPML, not only agreeing on an MDL, but agreeing on a jurisdiction, you're actually very likely to get that jurisdiction. When you come in with competing jurisdictions, you might get one or the other, but you might get a totally different place. So that's just, that's just kind of happening more broadly now.
Totally agree.
So it sounds like California's a problem. We're going to have to closely watch that state in terms of how the BMS decision plays out. The other states seem to be a little more in tune with the decision. And down the road, perhaps there will be another Supreme Court, let's say version 5.0.
Yeah, I guess that's right. I guess it is. It's certainly an issue that I think is going to, both on the class action issue, on whether BMS applies in federal courts, how it applies in federal courts, on which statutes, does the federal statute make a difference? All of these questions are ones that are percolating and that will get to the Supreme Court at some point.
There's one kind of like, it's like a gnat that's like flying around your head that's kind of an undercurrent in these decisions, but has not been squarely addressed from the Supreme Court, and that's this notion of consent jurisdiction. I think you alluded to this in your opening remarks, but every state has a statute that says in order to do business in a state, a defendant has to register to do business within that state. You have these registration statutes. And a number of states also have statutory provisions that say if you register to do business in that state, you are consenting to service of process in that state for any and all matters. There have been these, going back to 1917, like a handful of decisions from different courts around the country that have basically said that if you, based on these statutes, that if you do business within a state and choose to register, you didn't have to do that. You didn't have to sell your product in that state, but once you do that, if the state makes it a condition that you can be sued for process for any and all things, well, there you go. You have then consented to jurisdiction where you might otherwise have been able to escape it. Now, what's interesting is this issue of consent jurisdiction came up in Daimler, and Justice Ginsburg didn't address it. And I just reread last night the BNSF case, actually, because it was in Harold's outline of questions. I wanted to make sure I brushed up on that case. And it came up again in that case where the plaintiffs argued that even if there was no jurisdiction under Daimler, there was consent jurisdiction by virtue of a registration statute within the state. Now, Justice Ginsburg could have just said, that's ridiculous, because if you adopted that argument, you would undermine the whole of Daimler. But she didn't. What she said was, the Montana Supreme Court didn't address this question, so we're not going to address that question. Now, I think there's no chance that the Supreme Court would actually accept this theory, but it's being made in the lower courts. It's something to watch out for, and it has not been expressly shut down by the Supreme Court.
And so I agree with that totally. I think that ultimately, if this issue gets to the Supreme Court, there is almost no chance it rules that this form of essentially compelled consent to general jurisdiction is appropriate. So there are two ways that that courts have been handling this. The first way is to say they take a look at the registration statute, and to avoid the hard constitutional question, or at least harder constitutional question than statutory question of whether it's a due process violation to compel jurisdiction in this way. They've said we're going to interpret these registration statutes not to demand that compel jurisdiction. The Second Circuit did that in a case called Brown versus Lockheed Martin, and I'll read from that in a second just because I think it's a great explanation. And then otherwise, though, and there are a few places where the statute is totally clear that that's exactly what the state is trying to do, so you can't get around it by creative interpretation, then you're faced with this constitutional question. The trend has almost entirely been in the direction that Anand has been saying, to say, no, no way this is consistent with Daimler. The Delaware Supreme Court did the same thing, and we've been working with the chamber to brief that issue. But I'll just give you this line, which I think fits exactly with what you said, which is that if mere registration without an express consent to general jurisdiction nonetheless suffice to confer general jurisdiction by implicit consent, every corporation would be subject to general jurisdiction in every state in which it registered, and Daimler's ruling would be robbed of meaning by a backdoor thief. It's a colorful language from the Second Circuit, but I think that is exactly what you said, and I think that's where the courts are going on this issue.
Well, based on our research, I think there were 4 states that actually embraces this extreme minority view of using consent jurisdiction as a way of reaching out-of-state defendants. And so I look at Nebraska, Minnesota, Iowa, and here's the big one, Pennsylvania.
Yeah.
So
Yeah.
if there are any challenges on this, as the defense community considers this, to bring it up to the Supreme Court, to put that nail in the coffin that we really mean it on consent jurisdiction, perhaps that's the case, because the last time I checked, there's a lot of activity in that good old Court of Common Pleas in Philadelphia.
Yeah, for sure.
Well, why don't we open this up to questions from the folks here in this room? Unfortunately, we can't get questions from people online, but we have our mic runners, and if you can just announce who you are and ask a question, by all means, this is the time to do it. Speak now or forever hold your peace. Hold on for one sec, Professor.
What is your judgment about the Supreme Court policing what it's done and actually taking cases from lower courts where they run afoul? Because they only take a limited amount of cases, as you know. And the plaintiff's bar tells me, with a number of cases affecting civil justice, they're going to push their courts to do it with the hope that my phrase is that the teachers left the kindergarten.
I mean, it's a very good question, and you would think that they would let a lot of this percolate in the lower courts like they do in a lot of other areas, but on jurisdictional issues, they have been taking cases. If you just look at the last 7 years in the Supreme Court, they're on just almost the same issue. There's Goodyear. Then Daimler was the "we really mean it" case. In Goodyear, they came up with the at-home test, and Daimler, just 3 years later, is the "we really mean it." Then there was the Bristol-Myers case, which said "we really mean it" too. And then there's the BNSF case, which was really another general jurisdiction case, exactly like Daimler and Goodyear. And Justice Ginsburg wrote it again, and said "we really, really mean it." So I think she's very interested in this area. She recognizes that the lower courts are resistant to this paradigm change, but she feels like the old paradigm was never really embraced by the Supreme Court, and she is policing it. And she's got the court behind her policing it. So I think if lower courts run amok, we will see more decisions from the Supreme Court.
So I'll offer both a reaction to what you said and then also try to answer the question from my own perspective. But you know, it's interesting because I think it's fair to say, as defense lawyers, we often view Justice Ginsburg as not reflexively pro-business, and yet her decisions in this area have been supportive of I guess the business view of things. And I do think some of this has to do with her extreme care on issues of civil procedure. I think that, you know, she is a proceduralist, and that explains her decisions in this area that, you know, I guess on a surface level might seem counter to type. On the question which Victor, you asked, which I think is a very good one of, well, you know, basically can the plaintiffs get away with it if they just keep trying in various, you know, bad forums? Will the Supreme Court come in and help? I think, you know, no defendant should assume that the Supreme Court is going to come to their rescue, but every defendant should preserve issues for Supreme Court review in case either your case is the one that gets to the Supreme Court or some other case affects it. And that's sort of the lesson of some of the bad waiver cases in difficult jurisdictions. And I will say, you know, we work with the Chamber a lot on this. The Chamber is watching. The Chamber is looking for cases. If you have a case that you think is important, tell the Chamber. We've written a number of briefs, both in the Supreme Court and lower courts, trying to identify ways to continue to develop the law in a way that ensures that defendants have fairness in this area.
Any other questions? Doesn't seem to be a shy crowd.
We covered everything, I guess.
Yeah, I guess so. I'm going to ask you one question just as a matter of color commentary, I suppose. I mean, you were in the Supreme Court argument and on the BMS case. What were your impressions just by engagement of the justices? How vocal was Justice Ginsburg or Justice Alito on some of these matters?
So Justice Ginsburg asked, I believe, one question, and she basically asked, isn't this an end run around Daimler, which was a very happy question for her to ask. So it seemed that, but otherwise she was not an active questioner. I would say, I mean, Justice Sotomayor was when Neil Katyal argued for us, Justice Sotomayor was clearly the one who expressed the most skepticism. The other justices really didn't push back very hard on our arguments, other than at the margins, what are the consequences of this? The what's the big deal question that you get a lot, I got a lot in the lower California court arguments with Justice Kagan asked that kind of question. But it wasn't, I mean, oh my God, when I argued this in the California Supreme Court, I was like under attack from, all, it was like 7 justices sitting there, and it was like boom, 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 like, let me find this hole in your argument. What about this? It was nothing, it was not like that. I think it was like that for the other side in the U.S. Supreme Court, but not for our side. But it was really Justice Sotomayor kind of advocating really for a limitation on this paradigm shift.
Well, you should have expected to get those difficult questions because you're from New York and you went into the California Supreme Court and they wanted to know what's wrong with California, and
Exactly.
It's a great place to visit, but you wouldn't want to litigate there.
Well, any parting thoughts before we conclude this session?
My only thing is that I think, we all breathed a big sigh of relief after Bristol-Myers decision came down, and it remains like really the icing on the cake in a series of paradigm-shifting decisions. But it's not the end of the story. And I think our paper that we worked on with the Chamber points out some of the ways that the plaintiffs' lawyers are trying to get around this decision, and sometimes with some success. So it's just very important to be vigilant about these issues, make sure you're preserving it, and make sure you're kind of tying these cases together in the way they should be so that it can advocate to the lower courts that it really is a different world out there.
So I'll say 2 things in conclusion. First of all, I didn't work on the report, so I can say with authority that it's a fantastic report, and everybody should read it. It really spots the issues that I think are percolating in the courts today. And then I guess just for practitioners, raise these issues in your cases where they're appropriate. It can't be overstated that if it's not raised at the start, you could lose these arguments through waiver. It's very easy to waive personal jurisdiction, both in federal and state courts, and there are some great arguments to be had.
Well, final parting thought as a representative of ILR is that we are celebrating our 20th anniversary this month. And back in 1998, the forum shopping was like the Wild West, I suppose. But in retrospect, when you see what Congress did with CAFA, and you've seen the litany of Supreme Court decisions just in the past decade, it does seem as though the playing field has definitely been a lot more clarified, and that the defense bar has the tools that they need in order to sustain some of these core principles of personal jurisdiction that I alluded to earlier this morning. So, gentlemen, thank you very much for a great, thought-provoking discussion. I hope everybody in this room has gotten a little smarter on these issues. And also thanks to Oriana, her team, to Brian and everyone for pulling this all together. It's going to be something to watch out for. Maybe we're going to reconvene here in about another 370 days to see where we are. But thank you very much. Thank you for the folks online.